Thank you very much, and good evening. I appreciate the opportunity to appear here today on behalf of PORAC. I'm a labor attorney. In fact, I studied labor law under Professor Winograd at Berkeley, and I understand the importance of procedural representation rights, which is why POBR is so important. My clients and I have worked with stakeholders and the leadership to address many of the concerns underlying this bill, including modernizing force standards, increasing transparency, and Senator Bradford's bill, which set a procedure for decertifying officers who commit serious misconduct. I'd first like to clarify what POBR does and doesn't, though. POBR primarily provides procedural rights during an investigation that largely mirror the rights that unions have. It's not about getting off on a technicality. It's about things like before an officer is questioned or interrogated, they receive notice, the right to get a representative, the right to record the interview, the right to use the restroom. It's also about due process, that officers receive a right to access their personnel file, review adverse comments, write rebuttals, obtain exculpatory materials that are withheld from an internal affairs investigation. These remedies are really modest, and they primarily deal with the admissibility and the access to evidence. The first remedy that you usually see is suppression. It's modeled after the exclusionary rule in criminal justice. Unlawfully obtained statements or evidence may be excluded where appropriate to cure a violation and to disincentivize agencies from continuing to have further violations. Secondly, it also provides a mechanism to obtain evidence improperly withheld. This is very important as administrative appeals often have limited discovery procedures and access to that information. I've successfully enforced POBR rights on several occasions over my career, and I can tell you, in none of those cases did a procedural violation result in a discipline being overturned. Most of the cases I've handled involved the suppression of officer statements where they were unlawfully interrogated without a union rep. In those cases, without exception, the court expressly allowed the agency to continue to pursue the disciplinary case, but simply prohibited the agency from using the ill-gotten statement. In fact, in all of those cases, the circumstances where an officer was interrogated without a rep and without notice on the spot, they were subsequently sent to internal affairs and the rights were afforded to them. And the subsequent statement in internal affairs is and was admissible, and the court allows the case to go forward, just like in a criminal case where evidence is improperly obtained. The other type of cases that I've dealt with involved access to material, and I, in fact, argued one of the seminal cases, the Sacramento Police Officers Association versus Venegas, the published Third District Court of Appeal decision that established that peace officers have a right to access adverse comments contained in their internal affairs files that are used to hinder their career path.
Mr. Mastagni, just to let you know that you're just about 2 minutes, and it's going into the second witness's time frame. I apologize. The second lead opposition witness, Mr. Ryan Sherman, is giving up his time or a lot of time that you may need in order to testify. So please proceed.
I appreciate that, and thank you, Ryan. This bill is also unnecessary because the Supreme Court ruled a long time ago in 1988 that it's an abuse of discretion to overturn discipline or even to suppress a statement in certain circumstances over minor violations. Supreme Court precedent is binding on every court in California, including on the administrative bodies. The court in that case laid down a but-for analysis when considering a violation and said that reinstatement is not proper where the employer would have reached the same conclusion without the POBR violation, and that's very consistent with all of my experiences. The court even in that case said that suppression wasn't appropriate when the officer's right that was violated was not prejudiced, and it wouldn't be likely to have a future deterrence effect. And the court said also that suppression is appropriate in some cases where it's an effective deterrent. This bill would prevent a trier of fact from having the discretion to fashion a remedy for POBAR violations whenever the evidence of misconduct is significant enough, according to the bill, to outweigh the significance of the violation. This would create a perverse ends justify the means incentive for investigators that would be unacceptable in any other context. No one would support allowing police investigators to violate Miranda or Fourth Amendment rights just because the investigator believed a suspect committed a serious crime. The same applies here. In fact, the converse is really true. The more serious the matter, the more important it is for investigators to follow the rules and afford people their rights. This bill goes too far by eliminating the trier of fact's ability to exclude improper evidence and incentivizing interrogation violations by eliminating agency accountability. We should not be encouraging any law enforcement investigator to cut corners or to violate rights in any context. We need a culture that fosters officers affording rights. And Mr. Chairman, your bill SB2 also obviates the needs for this bill because SB2 provides a separate procedure to decertify officers who engaged in serious misconduct. Significantly, the POBR rights do not apply at all in the SB2 decertification process or procedures. Thus, it's unnecessary to clutter POBR with a balancing test between the violation
Sir,
and
we're going to
the
have to
alleged
ask you
misconduct.
to close. You've been given Mr. Sherman's time as well, just about 2.5 minutes.
And that was actually my last sentence. I was just going to close with it. SB2 already defines serious misconduct, and that process operates completely independently of POBR and the discipline process. And I thank you for your time, and I apologize for going over.
Thank you very much for your time. We'll now continue with any witnesses